Morning, everyone, at least I think it's probably morning everywhere where you are. I am so glad that you are attending this webinar because this is a topic that I think is vitally important to the good performance of all of the people who work in our system related to protection orders. As a result of this webinar, participants will be better able to understand the link between animal cruelty and domestic violence, and we'll also be able to consider the types and nature of animal-related relief available in civil protection and other court orders. So I want to just give a little background as to why I believe this is an incredibly important thing to learn about. And that is that throughout my judicial career, I would be very struck with what I didn't know once I learned something. So you can't see what you aren't looking for. And I will remember always that I was in a meeting with some people who were working at the Oregon Humane Society, and they were talking about the fact that they had conflicts that walked in their door about people dropping off animals, and then people coming back the next day saying, "Hey, that's my dog, and he just did that because he was trying to get back at me for something." And that was the constant sort of problem that they had, and they needed help. They needed help from legal recourse. They needed help from lawyers. They needed help from people seeking protection orders to actually allocate who was in charge of the animal. So over time, what I became aware of, and what you will hopefully become aware of as well, is that resources are necessary to help victims and their companion animals for safety planning. But also there are resources in your community. If you're judges, you just maybe don't know about them, or you should be asking questions to try to help create them. So without further ado, we're going to move on a little bit and talk about why this is underlying the entire process for us. That is that a lot of families have pets. Statistics tell us 70% of US families have a pet in their household, and those pets are important to people. I don't know about you, but when I've had a dog that I've had to put down, it's been the worst, several weeks of my life in many respects. Kind of ranks almost up there when the times when my parents died. They are integral parts of people's families. And when we don't think about them, what we do is create a situation where people are not going to be safe. So as we know, children talk to pets. We bring dogs into courtrooms frequently to help kids testify in some places, and other people who may be complaining witnesses in criminal cases. But in any event, we know that animals are very important to families, to children, to people. So we need to figure out how to include them in our plans for people who are experiencing violence in their home. We can move on now. What do we know? We know that after years and years of research, that there is a link between animal cruelty and interpersonal violence, such as domestic violence. And I will also say, just as we move on to the next slide, where we can see the Venn diagram that really shows what research tells us. When animals are abused, people are at risk. When people are abused, animals are at risk. And notice that we were focusing in on domestic violence today and interpersonal violence, but I will also say that I have seen animals used as tools to perpetrate elder financial abuse as well. So let us not forget that that is also part of this process and could be part of your statute. So important that you investigate that. And we can move on. So awareness of this link between animal cruelty and violence in our homes is critical to understanding how to create and craft protection orders that will allow for the safety of the people seeking the orders, will lead to prevention of violence, and will also perhaps assist in the breaking of the cycle of violence. All of those things are things that if you're not thinking about it, you're simply not going to see it. And that's the bottom line. So I'll say more later about what judges need from lawyers and from people working in the system to assist judges in making good decisions. But for now, let's move on to the next slide and sort of get more deeply into where we are here. So attachments can be used to manipulate, intimidate, or control. And in fact, companion animals or pets are part of the Duluth wheel. I'm certain that everybody on this webinar is very familiar with the Duluth wheel, but it is in fact a wedge that can be used to keep people in situations that are not safe for them. And we know that probably from your own anecdotal experience, but also because in the research, victims of domestic violence report that they delay escaping from abusive partners because they are fear that their companion animals will not be safe. And this is one of those situations where, again, I was sitting in a meeting where people were talking about the fact that all the shelters in our community where I was working in the Portland metropolitan community did not have a place for people to bring their pets when they were needing to seek shelter. And so all of the shelters were working together to try to create places where people could in fact take their dogs and cats when they were leaving abusive situations and moving to a shelter. Batters also abuse pets using more controlling behaviors and more forms of violence when they do. So there has also been an increase as people have stayed home during the pandemic. We see an increase in the risk factors for victims and for their animals because the people are just around more and were not allowed the same points of separation that they otherwise would have been had we not been in the lockdown kind of situations that we were in there. So there is a link and we need to be paying attention to it, and we need to have the information that we need to know what our options are, both as people who are working in the court system, but also people who are working in the community. And I think we're going to move on to the next slide. Here's where we talk about what do we need to know to help victims and make the best decisions in these situations. Judges' decisions are only as good as the information we have when we make them, and how we get information is controlled by a very tight set of rules. So we need advocates, guardian ad litems, self-help centers, lawyers, everyone who is working in the system, who is charged with the duty of bringing information to the judge to work at their best levels, to get us the information we need to be able to identify this issue as an issue in a case that we may be hearing, and to understand how to best address it in the most safe and appropriate way in the orders that we issue. Certainly judges can ask questions, and judges do ask questions and should ask questions. And interestingly enough, my experience has been when judges start asking questions, people come prepared to answer them. So we can help both on the bench and off the bench, and we'll get into that toward the end about raising the level of practice. But most definitely, advocates, GALs, self-help center staff, and attorneys all need to be aware of this issue and working to their best level on this issue, so that the orders that we enter are safe and appropriate orders which address the actual needs of the family. And we'll move on. We're going to move on to Stephanie getting a little more deeply into the ordinances, laws, statutes that are across the country that may assist courts and court authority in the protection of human and animal victims. So Stephanie, take it away.
Great, thanks Judge Tennyson, and welcome everybody to today's presentation. We're going to take you through a few different resources that are available to learn what's happening in your state if you're not quite sure about the breadth of protections available. Our focus today is obviously civil protection orders and what can be included in a protection order when it comes to pets and animals. But there may be a whole wealth of other things available as well. This issue comes up often in divorce and custody matters, which I think Amy will talk about a little bit later as well. But the issue gets raised in a number of different ways. So it's best to be prepared in all the ways that it may come up, or ways that you may want to delve a little more deeply to determine whether or not it's an issue. Let's go to the next slide. This next slide is a super fantastic resource if you are looking to see what is going on in your state. It's a map that just sort of gives you a bird's eye view of which states allow protection orders to include pets. Every state in green does have a law that allows pets to be included in domestic violence protection orders. There is a link there. This is a map that was created by the Michigan State University College of Law. They have an animal legal and historical center. It is a huge legal policy library for all things animals. This is one of the many, many maps that they have available. They have all kinds of ways for you to search through domestic violence issues and pets, as well as any issue involving pets, custody issues involving pets, criminal issues involving pets, all of those kinds of things. I highly recommend you copy that link down or save it now, or I'm sure everybody will get the PowerPoint at the end and can visit that site. I will warn you, it is a deep rabbit hole that you can get lost in pretty quickly because of the sheer volume of information in there, but they've done a really great job. This gives you just one of the many resources they have available, which is, the list of which states have pets included in domestic violence protection orders. When you go into your states, you can click on each state. It's an interactive map where it will show you the actual statutes that apply where you're at. So I highly recommend taking a visit there. Speaking of, we have another map on the next slide, which is a map from the Animal Legal Defense Fund. They every year compile a number of data points to rank the states from top tier, middle tier, bottom tier in terms of their animal protections overall. So again, the link is there for you. When you click on your state, it will take you to a number of different resources. There can be a PDF summary of all the laws in that state and their animal protections, pending legislation and pending cases that would affect animal issues, and recent state victories going on in that state. So it's a great site as well, just to familiarize yourself with, to know what is happening in your state or nearby, or take a look at those green states. The green states are the top tier states, see what they're doing and get some ideas of things you could adopt in your own state. There's nothing wrong with a little borrowing when it comes to this issue, and trying to get all those states up into the green category if we can. So the next slide is going to talk about kind of some other options as well. If your state does not provide explicit protections, there may be other avenues to still advocate for the pets within a case if you're on the attorney side, or include those pets if you're on the judicial side. Look at your definitions of domestic violence. Domestic violence can include some catch-all provisions. I know here in my state of Nevada, we have explicit protections that allow a temporary domestic violence protection order and an extended domestic violence protection order to include safety provisions for pets and animals. But there's also a catch-all version where the judge is allowed to issue any other relief necessary for the safety of the parties. That's a broad category. Judges have wide discretion to determine what would keep those parties safe. As you heard Judge Tennyson talk about, the abusers know on that power and cycle wheel how to use animals and pets to manipulate and control parents and children within the home. So this is not an issue that should be an afterthought. It should be an issue at the forefront, because it can, in fact, be one of the major factors determining a family's future safety. Quick little mention of the PAWS Act. It's the Pet and Women's Safety Act. That was, it's federal legislation from 2018, 2019, broadens the definition of criminal stalking to include animals, horses, any person who might experience a reasonable fear of death or serious injury to the pet is now subject to criminal stalking. It also allows for interstate enforcement of protection orders that include pets and animals. So if you are in a state that does not include explicit protections for pets and animals in your domestic violence statute, but one of our Nevada residents moves into your state and wants to register their protection order, the PAWS Act allows the registration to give that entire provision effect in your own state, even if your local laws would not normally include it. So, and I do want to take one quick moment also to mention, when you're examining your own state's laws or any state's laws, check on the language used. Some states depend on protections for pets or companion animals. They use different language. Some refer to just animals in general. Here in Nevada, our protection is for animals, which can encompass your companion animal at home. It can encompass a whole ranch full of cattle. There are some states, I believe Oregon, that more explicitly defines it to include companion animals. So the limitations are going to be dictated by what your state statute, how your state statute refers to those. All right, next slide, please. So working with survivors. In my day job, I oversee a self-help center, the self-help center at Family Court here in Las Vegas, which is a busy, busy, busy self-help center. We assist people with all range of domestic issues, family law matters, including domestic violence protection orders. Regardless of where you fall along the line, you wouldn't be here at this webinar if you weren't somehow interacting with the litigants within these kinds of cases. As Judge Tennyson said, I trust you've all been well-trained in trauma-informed practices. If not, or if you oversee a staff who has not been trained in those issues, I highly, highly encourage everyone to take advantage of a ton of free resources out there to make sure that anyone who comes into contact with a domestic violence victim has as much training and know-how to interact with those litigants as possible. Working with a domestic violence survivor, it's very different than working with any other kind of litigant in family court, which is the subject of multiple other webinars we don't have time to get into extensively here. But the trauma creates some serious long-lasting impacts on how they see the world, how they interact with the world, how they interact with people along the whole spectrum of the legal system. So
Stephanie, I just want to interject here, sorry, that one of the things that we learned when we were involved in the Family Court Enhancement Project was that judges received a ton of training on trauma responsive activities, but we had not thought to include our staff in that, our court staff, the clerk's office, anybody who was actually on the front line, and boy, were they happy to have it. So I really encourage everyone to listen to that because it was just a glaring omission on our part, which was once corrected, people were so much happier in their work, quite frankly, because they understood why they were, why people were in many ways coming at the problem in a way that was not as helpful to them as it could be. So
Absolutely. Thank you. Thank you for noting that, because it's very true. You know, the high level court staff receive a lot of training in their positions, and we sometimes forget about the frontline staff. My self-help center staff, the clerk's office staff, the marshals at the front gate. Just think about all of the people that somebody interacts with when they are accessing the court system. If the judge is well-trained in trauma-informed services, that's fantastic. But of course, the person has probably had 10 to 15 interactions with different people prior to getting to the judge. And at every step along the way, there can be some significant barriers where they might meet resistance. People who don't understand what's going on could get them to opt out of the system altogether. For some people, it doesn't take much for them to decide the system is against me, the system doesn't understand, there's no point in pursuing this. So be aware of that. We've listed some resources. First and foremost, your local domestic violence agency is often going to be happy to provide free training for anybody you ask for. Pretty much all of them have an outreach department whose mission is to educate the community. And they've done several trainings for me and my staff, which have been absolutely invaluable. There are some other resources online. Noted a couple of them here. Office for Victims of Crime. They have a free online training program. It's 38, I believe 38 different modules, between 30 minutes to an hour each. You can pick and choose which ones you want to do. You don't have to do them all, but there are a good batch of them dedicated to domestic violence issues and working with victims. And then the Ohio Domestic Violence Network Manual, amazing, amazing resource. They keep that updated. It's right there online, available for anyone to download. It explains trauma-informed practices in layman's terms, very easy to understand. Really, they presented it in a way that just connects with people really well. And then the Family Court Enhancement Project, which Judge Tennyson was involved in, up in Multnomah County, has some great resources as well. I think the next slide, I'm going to turn things over to Amy. If you want to go ahead and cover the rest. Thanks.
Hello, everyone. Thanks again to Stephanie and Judge Tennyson for getting us started, and to everyone who's attending today. As what's been touched upon already, is working with victims of or survivors of domestic violence is not a black and white cookie cutter issue. It's fairly complex and unfortunately very prevalent. And then as we've learned, about 70% of our households are pet owners. So with the prevalency of DV in our households, there is more likely than not to be animals involved in those situations. Just to give you more of a specific idea of how prevalent the issue is, you have about 1 in 4 women and 1 in 10 men who experience some sort of physical abuse, sexual abuse or stalking by an intimate partner sometime in their lifetime, and that ratio tightens with just some form of physical abuse by an intimate partner. And as Judge Tennyson earlier stated, if there's abuse towards animals, then there's likely to be abuse towards persons in the household, and vice versa. If we find that there's domestic violence in the household, the animals are more likely at risk of abuse as well. So when working with victim survivors of domestic violence, a big part of it is recognizing that this is even an issue with that client. So can't stress enough the importance of training, being able to recognize the signs of domestic abuse or domestic violence, but also being able to recognize the areas or intricacies that you may not know or understand as well, and then taking additional steps for further training and understanding. Also, when working with victim survivors and doing a plan of action for them. Also recognize that we are not confined within the four corners of the law, and there's so much, it's more expansive than that in being able to provide trauma-informed resources and referrals and services to these people. First and foremost, you got to assess the situation and the lethality. Is this person at high risk? Are they still in the household or sharing a household with the abuser? And, you know, do they need to remove themselves from that situation before you can even take a step further in what else they can do? Also, you'll learn that when leaving a domestic violence situation, that is the highest time of lethality. So if you are working with someone who's needing to leave the situation, please keep that in mind. Next, you need to identify your client's goals. If their goal is simply safety, you got to work on that, and it may not require the law or the court system. If their goal is relocation or you know, definitively getting a divorce or seeking custody and visitation orders for their children, or again, safety through a protection order. Those are all things you need to identify before you can move on to the next step. Identify who and what needs protection, if that is the goal. It may not just be your client. You have your secondary victim survivors, which are typically the children in the household. And in this case, also keep in mind that it's the animals and pets as well. Next, you'll want to identify what the client knows and what the adverse party or the abuser knows to help in your assessment and strategy and how you're going to provide services to these persons. Oftentimes, the more the abuser or adverse party knows in terms of identifying information or even have kept documents that relate to that, then you have to be a little bit more intricate in your planning and strategy with these situations. Next, identify what options your client has, how to access those options, and what are the pros and cons, or specifically what are the risks with each of those options. Those might be things such as relocation, whether it's just from the household to temporary housing or shelter location, or relocation to a completely different jurisdiction. Another is how can they get out of their current housing situation if they're committed to a lease? Does your jurisdiction or state provide options or avenues for victims of domestic violence to prematurely terminate their lease without penalty? Next, does your state offer a confidential address program? I know here in Nevada, we offer that program, but it's not transferable outside of the state. So that's especially helpful. So your client cannot be tracked through their address or mailing, and they're assigned a fictitious address to use. This is especially helpful when dealing with government agencies who often share information. Your children's schools and their records can utilize this program. And it's an alternative address for your client to use when filing in the court system. Next, is a report necessary or needed with law enforcement or CPS? This is a great way to document and have evidence of allegations of abuse and establishing further action in the court, whether it's in a criminal context or civil, such as a family case or protection orders. Next is actually applying for a protection order. Sometimes it's required, especially with persons who work with agencies such as Child Protective Services, but also assess whether a protection order is actually going to protect your client or actually exacerbate the situation and put them at a higher risk. However, if you seek a protection order, again, this helps establish some sort of documentary evidence of allegations of domestic violence and what's going on in this person's life and household. It documents the necessity and need of protection of your client and or secondary victims, again, such as the children and pets. And it establishes protection for a varied length of time. I know it varies between the different states and jurisdictions on time. Here in Nevada, it's an initial 45 days and it can be extended up to 2 years. And this often sets the precedent, especially if those hearing masters establish some sort of division of property, which could include the animals in the household, as well as some sort of visitation with the children. And then that could be carried over or influence your family case. Next, whether a lawsuit should be pursued, whether it's criminal or some civil action, whether it's a protection order or a family case. Criminal, it would be based upon whether your client decides to report with law enforcement or not, and or be a cooperative victim witness. But again, these things can be helpful ultimately in achieving their long-term goals with independency from their abusive partner, as well as establishing a safe custodial and visitation arrangement for the children and pets. Next slide, please. I think this will segue into the next slide, but become familiar with your local resources as well as resources with amongst the states and on a national level. Stephanie provided some great resources, but some are going to have limitations. I think the more local resources are going to be most helpful initially, and doing short-term as well as long-term services for your client. Some things to keep in mind, I'm familiar with Noah's House that's pictured here. Great option, great organization, providing a shelter space for animals, for persons who ultimately become homeless when leaving due to a domestic violence situation. However, I know our Noah's House here in Nevada is not a confidential location. So again, identify your options and weigh the pros and cons and what are the risks. Next slide, please. Here's some more resources. Again, these are great national resources, but that you can take a look at. But again, become familiar with your local resources, whether it's your shelters and what programs they offer, as well as your local rescues. They do a lot of amazing work and provide maybe not a shelter setting, but a home setting for animals where they stay in foster homes. Another resource to keep in mind is your law enforcement and your animal control and animal abuse and neglect officers within your law enforcement agency. They may be helpful in, again, reporting and initiating safety and protection for your animals if there's some sort of criminal action, such as domestic violence that's taken place. They also will help assist in removing a pet from an abusive household that maybe you couldn't get out initially when leaving and you're trying to get them out of the household at a later time. You know, who's going to do good reports and records for you to assist you in further lawsuits or litigation. Next slide, please.
Can I give one quick little mention before you move on to the Red Rover? It's a great list of resources. The Red Rover Resource, they provide some pretty good funding grants for people who are trying to construct pet-friendly shelters for domestic violence. Their website notes, I don't know if anybody here is from Hawaii or Rhode Island or knows somebody in Hawaii or Rhode Island. According to their website, they are really encouraging anyone from those states to apply because there are a lack of co-occupancy domestic violence pet-friendly shelters in those states. So it's a great resource, a lot of money to be had. Take advantage if you're in one of those states or know somebody there.
I would 100% agree with that. If you have the opportunity to establish some sort of pet-friendly shelter services, please take that opportunity. There's a lack of those services, and yes, it's a growing trend, but there's not nearly enough. I mean, just in this last year, our biggest domestic violence agency here in the state of Nevada started offering safe shelter services for pets of victim survivors. And it's on a limited basis. But, you know, we just got to keep in mind that pets ultimately are becoming not just object or a companion, but there's a growing trend of pets really being regarded as another member of the family by their owners, and ultimately could be the one key factor in a client deciding whether to leave or not an unsafe situation. Next slide, please. So if you've decided that your best plan of action is to utilize the court systems for protection for your client and their pets, here's some things to inform the judges. As Judge Tennyson said, the judges make their findings and opinions based on the information they receive. So if they don't have the information, they can't provide a service to you, or ultimately what your goal is in your case. So identify the pets in the household. A lot of protection orders allow you to include pets on the application. Make sure that's not skipped on the application, and make sure the pets are identified. I'd highly encourage, don't just check the box to provide specificity as to the pet, such as what they are, identified as a cat, a dog, a rabbit, or whatever, what their name is, or a description. Because even at the end of the day, if you get an order that says the pets are protected with no description, it's going to cause confusion if you ever needed law enforcement assistance or otherwise. So again, identifying the pets in the household where domestic violence has taken place. Be aware of other concurring cases involving domestic violence and/or animal abuse or cruelty. This happens a lot, and as a family law practitioner here at Legal Aid, majority of our cases are representing victim survivors of domestic violence, and most of the time there's some sort of criminal law matter and or protection order that is also happening at the same time as that family case. So be aware, make your judge aware of those and or the initial allegations as well as the outcomes. Don't rely on the other case to also fulfill the client's needs. So there might be a no contact order, stay away order in a criminal matter, but that doesn't mean that the client can't seek or obtain a protection order. Next, child placement, child custody considerations. Whether there's children or not, again, with the societal trend of treating pets more like family members than property, you know, there's now a trend of also looking at best interest factors for the animals. It's been determined scientifically, animals are aware, they're conscientious, they have emotions, they're intuitive. So they're definitely affected by the transitions and what's taking place in the household and by those family members, much like children, and when we assess what's in their best interest and for placement and custody and visitation matters. And you'll often see that that's one factor that comes into play is whoever's the custodial parent or where the children go is typically where the pets go to. Again, because pets and companion animals offer much more, such as than companionship. They also offer emotional support and are therapeutic to also our clients and their children in these types of situations. Next slide, please. I think this is where we're going to transition to Judge Tennyson. But I wanted to offer a couple examples before we do that to just kind of give you a picture of some of the things we're talking about. For instance, I worked with a client who was a victim of domestic violence, still in the household, but surprisingly, there was 23 animals or pets. Um, so I'm just kind of stopped in my tracks, and the first thought is, what are we doing with all these animals? And also, would it be beneficial to your client for me to go to court and say she has 23 animals? Probably not. That's probably in violation of city ordinances and other things, or maybe their lease agreement. But ultimately, we needed to have a plan of action for what was going to do with those, happen with those animals if in the event she sought a divorce and or left the household. Another example was I assisted a client with a protection order, and her dog was just as much a client as she was, as the dog was the crux of the case. The adverse party had gone as far as using law enforcement, social media, local animal groups to help his plan of action, so to speak, to continue to victimize my client and or convince that he was the victim of the case and that his girlfriend had stolen his dog, when the actuality was she had left with the dog to keep them both safe. But in the meantime, she had added him to her accounts with the vet's office. She had also added him to the microchip registration with the microchip company. So what did he do? In the meantime, while her protection order was pending, he removed her from the accounts from the veterinary offices. He removed her from the microchip registration of the company. Those are the two most common or most convincing evidence to establish ownership of an animal, and her being removed from those would help establish him as the owner of the pet. So not only did this involve getting a protection order awarded and extended for her and the pet, but it was also reestablishing ownership of the pet for her and making sure the pet was safe. And in doing my research, there were prior cases, both civil and criminal, and in one he had injured the dog in the household so severely that that previous dog had to undergo surgery. So successfully, I was able to get her back on the vet record, get the microchip registered into her name, and have the dog added with specifically name and description, so we could get the microchip registration taken care of. So ultimately, in this situation, the dog was really what mattered most of anything between both parties, but ultimately we knew that the dog's safety was at jeopardy as well. Judge Tennyson, I'll go ahead and let you continue our presentation.
Thank you. And I think that what you just were mentioning, Amy, has some broader connotations as well, because we talk a lot in our National Domestic Violence Institute about the ways that people track each other through electronics now. And I think that we are getting to the point where people are being offered ways of tracking their dogs and cats on just not a microchip that just sits in the dog or cat, but something on the collar that actually tells you where the dog is.
Yeah.
And so these are things that I think people need to really be paying attention to, because it is just another way that we need to make sure that people stay safe. So we're going to move on now to talk about what judges can do. And this is where we really start to talk about judicial leadership, I think. So if we could move on to the next slide. So part of what we need to do as judges, of course, is to first and foremost provide a fair hearing for everyone. Fair hearing for everyone. That's our first duty. And once we get to the part where we are on the bench and we are providing the fair hearing for everyone, we also need to have some things in the back of our mind. And part of that is the consideration of the human and pet safety in the home. And we can do that because the statute charges us with that obligation, not because we are just imposing our own will. And so this is a dichotomy I think that all judges live with. We are all highly trained professionals. We have a lot of things rolling around in our head, but if it's not on the record, we can't do anything with it, right? But we can definitely ask questions that the statute or law directs us to ask. So that has to do with what to do about pet safety if we're being asked to address that problem, or to ask that question in the context of a hearing, especially if you hear information or testimony that's going to provide you with a platform to be able to follow up. There are all kinds of ways to ask a question that we may or may not get a good answer to. And again, as we're going through petitions, as we're going through the written documentation that we get, it's important to explore what people really mean by the written statements they're making in the documents that we're reviewing. So often people won't write down everything that they know. They have limited time to fill these things out. They're not well versed in what they really need to provide you, the information that they need to provide you. So always take a moment to ask questions if you don't understand what people are talking about. You are the finder of fact. So asking questions is an important part of the process. Important
Can I piggyback off that real quick? So since
Absolutely.
I work exclusively with pro se litigants, self-represented litigants, I will tell you, probably everybody here knows this, they are notoriously bad at explaining things in writing. The most common reaction that I will get from people, because our staff will explain, you got to write it down. If you want the judge to know about it, you got to write it down, explain it. Their retort to that is always, but when I get to the hearing, I'm just going to explain it to the judge, without realizing that judge is very busy and that judge has a whole lot of hearings to tend to, especially here in our domestic violence court. It's a high volume docket. You're not always going to get the opportunity to explain orally every little thing that's going on. And being in a hearing, virtual, in person, any way, shape, or form, is nerve-wracking for people. So they tend to lose their thoughts at the same time. Even if they go in intending to talk about it, they're going to forget. And they may not adequately explain it to you. As one very short example, the other day, we had a mom and her 5-year-old daughter come in to apply for a protection order. And mom's filling out all the paperwork. The daughter is talking to the staff member and saying, you know, the last time daddy got mad, daddy threw the cat in the garbage can. And that made me really mad. And I don't want to be around him anymore. The application mom puts together merely makes mention of, my child is afraid he's going to hurt her or the cat. That was all that was said. The actual incident wasn't explained. The judge didn't inquire about it at the hearing. The rest of the application was kind of a meandering statement that wasn't well put together. So the protection order was not granted. What we heard in the center versus what was presented on the paper and presented in court are two very different things. Had the judge taken the time to prod a little bit more into that statement, there could have been a very, very different result. And so I'm glad that this webinar consists of a lot of attorneys and a lot of judges. If you're an attorney, take the initiative. If your client needs a protection order, take the initiative to write up that protection order for them. There tends to be a perception that this is an easy thing to go do by yourself. Nothing is easy for somebody without legal training to do by themselves in the court system. So if you are an attorney with a client, represent the client in that matter. In addition to whatever else is going on, it can really make all the difference just in terms of how that gets presented.
I'd like to piggyback on what Stephanie said. We definitely took steps here at Legal Aid to provide services to assist in trying to prevent that sort of thing from happening. Before, we would just take protection order cases and provide representation on a subsequent hearing or extension hearing of a protection order, but attorneys typically weren't involved in the application or initial process and actually getting that protection awarded to the client. Before, there wasn't even initial hearings for a TPO application here in Nevada, and it was strictly a written application that was reviewed and a decision was made upon. So the sooner a victim survivor can receive that advice and counsel and even representation on a protection order matter that's right from the beginning, is going to be the more beneficial to that client, especially when they had that opportunity and didn't express the specificity of the situation. So they failed to obtain that protection order when we know on the outside that they are absolutely a good candidate for one. But then another thing to keep in mind is, do your state statutes and rules prevent them from reapplying on the same facts? Sometimes it's that one and done, and if they weren't successful on that initial application, they may not have the opportunity to reapply and better explain themselves.
I do think that that's a really good point, Amy, in the sense that what needs to happen is that people need to understand that you can't come in and ask for the same relief if you didn't get it the first time around. At least that's my experience. I don't know of many states that would allow people to come in on the same facts again. And so it's important that what people do is be prepared, be ready. And it is a tough atmosphere for self-represented litigants to do well in, because they are talking about very emotional issues. And you can watch people from the bench completely blank out. So, and there's something there, but they're just not ever going to get to it given the environment that they're in. So there are lots of ways to help that situation so that you, the judge, can get the information you need. Sometimes it can be as simple as, hey, just take a breath right now, in and out. But here's the other thing that I would just say, and then I'm going to get back to pets for a second. Why do we, as a community, tolerate the constant refrain of, these are very busy dockets, the judges don't have time? Why are we not reallocating resources for that? And I think that's a question that each community needs to ask themselves, because and that is judicial leadership off the bench as well. Because these are important issues. If you make a mistake in one of these cases, it has some incredibly long-term ramifications, not just for the two people who may be standing in front of you, but for all of the other friends and family that may be involved in the situation. So to me, appropriate amount of time is a really critical part of this process. And also having petitions that actually prompt people to give you the answers that you need. And I understand, believe me, I've read probably more of these petitions than I can count. And I understand that there are some people who are simply not going to be able to write it all down. And so what needs to happen is that functionally judges need to understand that and learn ways to get information that they need. Remember what it was like when you were a lawyer and you were trying to ask questions of your client to get information into the record. I mean, there are lots of things that we lose, and I'm putting that in air quotes, when we go onto the bench. And one of those things we lose is the interpersonal skills of actually talking to people. Important that what happens is that we include the issue of pets and pet safety from the fundamental understanding that pets are a barrier to safety for the people. If you cannot help issue orders that will provide solutions for the pets to be taken care of, people will make different choices about their own safety. And that's one of our higher duties, in my opinion, as a judicial officer, is to ensure that everyone is safe when we conclude the hearing and we launch people out into the world. So let's talk, since we're talking a little bit now, I think, about off the bench leadership, let's move on, because we have sort of a question that relates to that as well. And we'll move to the next slide. This has some more direct information related to what kinds of things you may want to include in protection orders. And I'm going to just slide on past that because I think we've talked about that a little bit. So next slide. Off the bench, many of us have in our communities coordinated community response teams, coordinated community response groups that meet once a quarter, once every 6 months, and work on systems issues. So this is where judges can take a real lead in helping to develop the solutions to some of the problems that we're talking about. It can be as simple as ensuring that the documents that you are using in your court include the question: are there pets in your home? Do you have concerns about them? Are they being used in a way that is making you uncomfortable? So there is that simple change to the paperwork that can help prompt the information that you need. It can be as complex as ensuring that what you're doing is providing training for your entire systems community about these issues. To me, that's the answer to the question that's being asked. How do you get people to take this seriously in your community? Well, you need to bring people in who will help you do that. As one of my colleagues in Kentucky used to say, it's hard to be a prophet in your own land. Sometimes what you have to do is bring in people from the outside who can help you create training that will point out the issues and will assist you in moving it forward in a way that's going to make sense. So again, this is a situation where when judges ask questions, when judges prompt discussions to occur, people actually pay attention to that and will often move it forward. But you do need to have allies. It's not like you can just single-handedly grab people by the collar and pull them up. You do need to have some understanding of how to move people and how to be a leader. And so there's training for that too. I mean, the National Council of Juvenile and Family Court Judges provides training on judicial leadership. I encourage you as judges to really pay attention to those sessions when they come up at conferences and otherwise, because there are ways to motivate people to make this change. Don't wait for the case that the center is going to be named for. It's kind of, interesting having traveled around the country and how many different places where the shelter is named for someone who was killed violently because people weren't paying attention to the domestic violence that was going on in the home in a way that was effective and was able to reduce it. Don't wait for that tragedy in your community. Get out there, start asking questions, call a meeting, educate others about the link. Once people know, they're much more likely to take steps. They can't say, oh, I didn't know anymore. So when that excuse is no longer available to them, then you feel many people feel compelled to do something. And many of the things won't cost much to do. So those are the kinds of things that I think people need to really address and realize, is that it could just be as simple as a change of practice. We ask a question in a different way. We divide a docket up so that 2 judges are covering it instead of 1. We make sure that the materials provide information to people about options for them along these lines. You convene people and you say, hey, I want to talk about this particular topic. Or you go to the already existing coordinated community response group and you say, hey, what are we doing about this? Judges sit at the center of their community. We know probably before most people do what the patterns are in the issues and needs of our community, because we see one case from the northeast part of town, and then we see the same issue and the same need from the southeast part of town. We see the same issue from the northeast part of town, and we know that what we need is to address that issue. Call the meeting, go to the meeting, identify with others what the problem actually is and how to put services in place to address it. In the child welfare world, we ask people to do that all the time for individual families. What I'm asking you to do is to do that for your community. There are all kinds of people out there, like animal control, humane animal shelters, welfare agencies, all of the professionals in our community that care about these animals and care about people. And they're really looking for people to assist them in moving the cause forward. And you can be that change, judges, but you need to make sure that what you're doing is doing it in a way that's planful and effective. And so again, what I would really encourage is getting some training if it's something that you're hesitant to do. There are ethical issues. We need to make sure that we're always on the right side of that. Not gonna, you don't do anybody any good if you lose your robe, obviously. But there are ways to do this in a very ethical and straightforward way. And I just encourage you to do that to the extent that you can. The other thing that I will tell you that has been enormously effective, in my opinion, is taking some of these tools and developing cross-disciplinary training. So now I'm talking about court, legal, social service, animal control, juvenile justice, all of the different people in the system, because you would be very surprised how much all of those parts intersect. And if everyone's level of performance is raised, how much better your system can work. And so there are some resources that the National Council has developed with the Animal Defense League that will assist you in providing roadmap for what a training might look like. And there is technical assistance available to do that. So that is an off the bench judicial leadership activity that will yield you incredible benefits if what you do is find a way to do cross-disciplinary training in your court system. And then I would also say that it is once people start actually talking with each other, they can in fact figure out who's connected to who. And once they do that, a lot of the planning out of the courtroom helps the information that you get in the courtroom and assists you in making orders that are going to be effective and address the issues that are actually there. So off the bench, as important as on the bench. You got to be good at your job on the bench, but you also need to be good at your job off the bench. And there are two full-time jobs. I'll just tell you right now, judges, and that's the way it is. So the sooner you sign on to that, I think the better I'm going to feel about the whole system, because we all need to be leaders and we all need to be really good at what we do when we're on the bench as well. So next slide, please. So this is the portion where we have some questions, and I think we have about 6 or 7 minutes. And I'm not sure if we have some questions that we want to entertain at this point.
Judge Tennyson, I noticed some commentary here at the end in the chat box that, might be something we want to comment on. Stephanie Resto mentioned a protection order case where they were able to go back a second time and get the protection order granted once it was explained more thoroughly. And I think she, again, brings to attention, of course, this does not always happen and judges are different with each case from case to case. And then the next comment is what we are finding in developing manuals, court paperwork is not keeping up with the law. So just kind of putting it in summation, the law is continually changing, and we have our laws within our states and laws in other jurisdictions that can be persuasive in our arguments if it's not already passed in our state. But yes, it's important to stay on top of that. But yes, at the end of the day, because where the law doesn't exist or is limited, then there's a huge amount of discretion on the bench from judge to judge. So I guess I would probably say try to familiarize yourself with that judge or hearing messenger best you can to, again, try to attain goals for your client.
So I'll just say that when we talk about developing manuals or court forms or court paperwork, one of the things that is critical about that is whether or not the state judicial department has any sort of a unit that is charged with developing statewide forms, or if those are county by county, because sometimes that happens. And so sometimes what it will be is you working in your particular county to ensure that the forms are up to date and match up with what the current state of the statutes are. Sometimes what it is that people develop these great manuals and these forms, and then what ends up happening is they sit on the shelf and people forget to do anything with them. So I really encourage you, if what you are doing is developing a manual or some other thing that really talks about procedures and has checklists and all those other kinds of things, that you do regularly train on those issues. It could be as simple as having a lunch session every month that picks a different topic, so that what people are having to do is stay up to date on those things. So those are two things that come to mind when I look at my experience related to forms. Obviously, every time the legislature meets, we need to review and update, but we forget that somebody needs to actually be in charge of that and taking a look at it. Not my strong suit, I might also add. I'm not a detail person. I'm mostly the big picture kind of person, but there were judges in my court who were very much understood how the nuance of law changes and how that should be changing our forms. And you just need to exploit their actual talent. So, yeah.
Yeah, and my life revolves around forms. And what I can suggest, just like has been said, each court system should have somebody tasked with not only creating forms, but maintaining forms. Sometimes forms get created by committee. There's a need, there's a new law, there's something that comes out that prompts some small group of people to build a form or update a form, and then that committee disbands. That is a terrible way to run forms, because your updates are going to lag far behind. If you don't have a central forms committee whose job it is to make sure those are up to date all the time, you're just going to lag behind. So it's a whole separate issue from what we're talking about today, but I could go on and on about that one.
It's funny.
Looks like we've got another couple of questions. We've got 4 minutes to go, but we've got obstacles. What does the group feel about obstacles for the states who have been able to move those protections for pets forward? Our speaker is Grace, and our questioner is Grace, and she's in one of those states currently. And
I just know that one of the biggest obstacles in meetings that I have been in is people not thinking that it's an important issue. And that I don't know how I think what you have to do there is have people really understand the issue that you're trying to address, which is it is a barrier to safety for people. And once people understand that as a concept, I think it makes it a little bit easier to move it forward. But you also have to be very careful of, there's just a whole lot of people who are not of the opinion that that pets are part of the family and that they belong, with the family. So they're property and that's what they are, and people can treat them any way they want to treat them. And so that may not be a mindset that we agree with personally, but it is a mindset that you have to figure out how to move around. And so I think developing better arguments about what you're trying to do by introducing these protections into your law is the way to go. And really, you've got to get some allies in terms of that particular approach in the legislatures that you're working with, because that's where it starts. So I don't know if Amy would like to take on the what do you do after the animal was not protected question that came from, I think it's Dana.
Kind of along the lines with addressing obstacles, know who you're dealing with and know what resources and options are available ahead of time, or research it, and try to think outside the box as much as possible. Your answers and options may not necessarily be within the law or within the courtroom. But with that, if there's an order that, the adverse party or abuser is keeping the animal against a court order, then clearly you have enforcement and or contempt issues that you could address with that. Sometimes it's something that, you're trying to handle in your civil matter, but there might be an avenue to really get achieved what you need to through law enforcement and initiating a criminal case. Sometimes it's a matter of just establishing that ownership through your vet records, the microchip registration, whatever, to your client, and then enforcing property ownership. And it's all levels. When you're meeting obstacles, it's through your family and friends, your neighbors, to your local organizations, to your judges, to your legislatures, and local and national government officials. And what I think is interesting is in 2006, federal laws were passed requiring states and local officials to include pets and service animals in disaster planning for, evacuation scenarios and or shelters, but yet we don't have that strong of protection for pets present in our everyday lives and in our average households. So it's really trying to fill that hole or gap, and we have it, their importance in one scenario of crisis. Why aren't they not that important in your everyday household crisis that we work with on a day-to-day basis? And that's just something to ask. And we also have expansion in our laws for protection, again, through a criminal aspect of things. But yet we only have, I think somebody posted, we're up to 6 states now where we have laws for pet custodial issues. In all 50 states, animals can be a beneficiary of enforceable trust. So, they have an equivalent status as if you or I were a beneficiary, but yet they don't have that status within our household. So, we do have a long way to go, but at least things are happening.